All right, now, with regard to going back to New Orleans auction, which you were
Okay.
as we discussed last time, basically, and I discussed earlier with the licensing, there is a proposal in place with regard to selling the stock of the auction. It would remain actually New Orleans Auction Galleries, but the stock would transfer from Gene Vito's to a third party, either Schaffenberg or another company that would outbid a Schaffenberg in the bankruptcy proceeding. And as we stated earlier, I would, basically, whoever buys the stock and is approved by the court, we reserve a right to review at that time, and I've made the attorney for New Orleans Auction aware of that. And further, I made him aware that we will go into court and make that clear to the judge unless that is part of the actual disclosure statement. And it's my understanding that he has either added or will add to it a requirement that any buyer have to be approved by the auction board to be able to do business. So that it would be in the auction, in the bankruptcy proceeding.
So I know Schaffenberg, and I saw another person, another company's name in there with a substantial amount of interest in the company. Is there a reason why the board, if either other company other than Schaffenberg wins this bid, is there a problem with another company taking over and being able to get a license, a business license?
Well, the business license is technically for New Orleans Auction Galleries. It's not a separate license. If they retain that company, because it's stock that's transferred. Now, if they could transfer it and shut down New Orleans Auction Galleries, that's a different matter. And start up a new business, that's a whole different issue. Because that would not be the same business. As long as it's operating as New Orleans Auction Galleries, it has to have a license from us to auction. It cannot, Gene Vito's will not be the owner of the auction of the stock, as I said earlier, once the sale goes through in the bankruptcy proceeding.
I understand that, but I mean, the name is assumes to be the quote problem of acquisition. The New Orleans Auction Gallery name.
Well, they're not selling anything other than the stock.
Correct. So
So it's still going to be New Orleans Auction Galleries. That's correct.
Correct, but we had on here New Orleans Auction Gallery business application.
Right.
So that name is in effect has to get a new business, and if this new company who purchased the stock, they would have to apply for a business license as well.
No. Not necessarily.
They don't have to?
No. Because basically there's going to be an approval process, but the license will still be in the name of New Orleans Auction Galleries.
But I'm talking about to operate an auction business.
The deal is that that is part of the disclosure statement in the proceeding, that an auction license is required, for whoever gets it. That we have a right to come in when this happens in the past, because we've had transfers of ownership of auction businesses in the past. And what happens is we investigate the new owners. And if there's a problem with them, then we can then revoke the license. But what we don't want to happen is that Gene Vito's no longer owns the company. And the new person has not gotten a license. They would then be operating without a license for a period of time until that approval process goes on. As long as the bankruptcy court is running New Orleans Auction Galleries, I'm not having a problem with it, because believe me, nothing is going to happen as long as that judge is watching everything they do. And there were disclosure statements filed, etc., so that there is a constant monitoring of what's going on in that company until such time as the bankruptcy proceeding is closed.
What question? Is she gonna remain there?
You don't know? That I'm told that she wants to remain there. That is obviously going to be up to the new owner, whoever that may be, and also at some point we're probably going to be reviewing some things with regard to the also.
Which we've already voted to give them the business license.
Yeah, but she's going to be only a contract auctioneer once the stock sells.
But I mean, as long as she has a license, they have a license, Louisiana auctioneer private sale, there's not even a problem. Because you have a licensed auctioneer who will be responsible for the taxes and whatever.
Now, but I want jurisdiction of the
I
company.
understand, I know where you're coming from.
Okay.
Mr. Burns has a question too, not that I'm.
But, I'm through the wrong
Okay.
one.
I'd like to get some clarification on this whole issue of transferring the existing stock. If you read the reorganization plan, you read the cram down provisions, it clearly states that the existing stock, if this whole plan is approved, is going to be dissolved and declared worthless, and new stock will be issued. Now, having said that, if MS Rao is successful in their motion to, in opposition to the exclusivity period for providing a reorganization plan, obviously it's their intent, as they have made known, to go in and seize the stock. And of course, that's pending before the judge as to whether or not that can happen. So I'm still a little bit confused about, you know, if we're going to say, well, we're approving a license once the stock transfer takes place. That's only going to happen
No.
if it's MS Rao.
No.
If under the reorganization plan, that stock's going to be canceled and it says it'll be worthless.
No. What's going to happen is as long as it stays in New Orleans auction galleries, the sale of the stock will transfer the galleries itself to a third party, whether it's a Schaffenberg. I'm not sure Rao is actually looking to do that other than to seize the money that they're owed. I am told that we're making some changes to the whole procedure to provide for the approval of the auction board for anyone who ends up with the stock or the business. So that if it's a third party that comes in and it's Joe Blow's, you know, auctions, then they're going to have a completely different license, and they will have to come before us for that reason.
So in other words, if a Schaffenberg's stalking horse bid fails and MS Rao's efforts fail, that the license that this board has just granted would not be effective, or it would be effective?
No, it's effective right now.
But would it be effective to whomever gets it?
It pursuant to court approval, yes.
Okay.
You know, because that's part it's been added as part of the requirement.
And the board doesn't have any right to go back and reserve to then evaluate whoever that successful
We
bidder?
always have the right.
Okay.
We're going to do that, and that's what I just said, that we're going to be actually evaluating whoever purchases it. I've already looked at a Schaffenberg, and I've looked at MS Rao, and now it could be anybody else who can put that bid in. So far, there doesn't seem to be an issue, but again, the approval of the court is going to be dependent to some extent on the ability of this board to approve whoever ends up with that ownership interest. So that, and we always reserve that right, because, for example, if there had been no bankruptcy and New Orleans auction had just simply sold,
Right.
we would have a right to go back in at that point and say, you know, in the middle of the year, I don't like the person who has that, we're going to revoke the license.
Right.
We go through the same proceeding we would always. So that's never out of the hands of this board.
Okay.
I just asked the court to add it to the proceedings to make sure the court's aware that there is a separate process, and that anyone purchases it, there's a separate process for approval
Okay.
for that reason. Okay, any other questions? Okay. And we're still monitoring this. I understand that the transfer, although I don't have specific dates yet, and they may have happened last week while I was out, but they seem to be contemplating this would be all over with by the time we get to, or at least we would know it's happening by the time we get to our next meeting in September.
One other question in reference to that, I know you mentioned something about some complaints that the
Right, there are two complaints that I'm aware of that have to do with authenticity of items sold, and these are buyers' complaints, not consigners' complaints. All consigners, to our knowledge, have been paid in full, and that was through the court proceeding. The judge had to approve every consigner's payment. So we are not aware, all the consigners, as I said at the last meeting, that have filed with us and all that we are aware of have been paid, and that's part of the listing in the court proceeding. The two that I'm aware of, and there may be actually a third one, only one is filed with us, has to do with what was sold and whether it was actually what was supposed to be. And those are issues that have to go to trial and have to be resolved, and will either be resolved through the bankruptcy proceeding or afterwards through a litigation.
Let me ask you this: the Jacob Kansas Loudon Room, how's that classified?
He's been paid.
Oh, he has been paid.
He has been paid. I checked with Mr. Peck. That situation, and I think most auctioneers know this, that if you have money in your escrow account and you have a dispute as to who is to be paid, because you, in this case, for y'all who don't know, what happened was that one of the consigners owed money apparently to more than one person, and One person had an assignment of proceeds from the sale of items to New Orleans auction, and the other had a garnishment. The garnishment was on a judgment. It was stayed because of the bankruptcy proceeding. The assignment also was stayed, and the court had to make a decision as to who was going to be paid because the consignor also wanted to be paid out of all this money. When you have a dispute to that, you cannot pay any of the individuals until the dispute is resolved. So, under the statute. So as a result of the fact there was a dispute as to who was to be paid, then they had to get that resolved with all three parties. It's my understanding that the court has approved the payment to Ladder and Bloom, who's represented by Mr. Kansas, and that the check, when I last checked a week and a half ago, was being cut, if it had not already been. The Casimos, who were the people who had the garnishment, had not been paid because of the court order, and that was stayed. And the Delani, who was the actual consignor, also had not been paid because they were waiting to see what happened with Casimo. Both Casimo and Ladder and Bloom filed in the bankruptcy proceeding and have claims. And that was all, for some reason, postponed pending some other things. So they were not showing up as part of the original consignors, but they were not technically consignors. They were people who were trying to seize items from a consignor himself who owed money to them. Okay. All right.
Come
Too much-
back on, we're over New Orleans auction.
Yeah, I think that's all on New Orleans auction unless anybody else has a question.
Next.
All right.